All right, a judicial candidate nominated by President Biden stumbled literally over some basic constitutional knowledge during a Senate hearing yesterday. And certainly that, as well it should have, is raising questions as to his qualifications for the position. Kato Cruz has been nominated for a lifetime appointment as a trial judge on the U.S. District Court for Colorado. But he performed literally what many are referring to as a faceplant at his nomination hearing. And the question that he just crashed on involved several Second Amendment issues that, although they might be issues complex for non-attorneys, these are issues that ought to be common knowledge for a sitting judge. Well, joining me now to break all this down is Ken Klukowski. He's a former senior counsel with the Civil Rights Division of the U.S. Department of Justice, also a former special counsel in the White House's Office of Management and Budget. He's also litigated constitutional cases before the U.S. Supreme Court. Ken, welcome back to Washington Watch. We're glad to have you.
Thanks for having me, Congressman.
You're very welcome. All right, I have a clip of what took place at Kato Cruz's nomination hearing, and I want to play this for you and our viewers and listeners. It involves the Brady Motion. Please play clip 6.
Tell me how you analyze a Brady motion.
How I analyze a Brady motion?
Yes.
Senator, in my 4.5 years on the bench, don't believe I've had the occasion to address a Brady motion in my career.
Do you know what a Brady motion is?
Senator, in my time on the bench, I've not had occasion to address that, and so it's not coming to mind at the moment what a Brady motion is.
That is just, it's almost comical, but it's embarrassingly sad that an individual like this is literally being considered. So there's more to this. I'll let you, Ken, tell us about it. How disturbing is this whole issue?
Well, this is troubling, Congressman. It's under the U.S. Constitution, as you know, as you've done it yourself, all officers in all three branches of government have to take an oath to swear to support and defend the Constitution of the United States. Now, knowledge about the Constitution is then of particular importance to officers in that third branch of government, the federal court system, because when there are challenges as to whether the Constitution is being violated, it's the job of that judge to know where the legal line is and to faithfully apply it to the facts of the case. And when it comes to Brady, Brady is short for Brady v. Maryland, which was a 1963 Supreme Court case, a watershed case, one of the big cases regarding the due process rights of people being accused of crimes by government, whether it's federal government, state government, local government. It's the rights that a citizen has when the government, with the almost inexhaustible resources of a prosecutor's office, is coming after you and can potentially be trying to put you in prison. So, and the holding in Brady, in that Supreme Court case, is if the government, with its vast powers and resources, ends up coming across evidence that shows that this suspected person might be innocent, that the due process clause of the Constitution requires prosecutors to hand copies of that evidence over to the criminal defense lawyer so that the defense lawyer can make sure that the judge is properly advised while this person is going to trial. So the idea that someone who's about to become a life tenured federal judge doesn't know about this bedrock of the American justice system, without which a lot of people could end up going to prison, not because they're guilty, but because, the single criminal defense lawyer that the suspect was paying out of his own pocket just didn't have the resources of a huge team of police officers and agents and prosecutors like the government has. And so when the government found out evidence that this guy might be innocent, but for Brady, they wouldn't necessarily have to give a copy of that over to the defense. And obviously then a terrible injustice could result if an innocent person ends up being convicted.
Yeah, that's my whole question with this, Ken. Brady is not some legal obscurity. This is something that every attorney at this level should know like the back of their hand. That it falls with the innocent until proven guilty, and if in the process of a trial evidence comes forward from on the prosecutor's side, hey, this guy's in it, then they are required to give that information over to the innocent person's attorney. How concerning, disturbing is it that we could potentially have an individual, a district judge, who wields the power literally to put people in prison, and this potential judge doesn't even know this most basic constitutional protection?
I think it raises some troubling questions, and obviously the Senate's going to have to work its will, and we'll see what senators on both sides of the aisle have to say about this now. But this is not some sort of procedural quirk regarding due process. This really gets to the heart of the due process clause, where the due process clause is about fundamental fairness. It's about what sort of procedures are considered to be foundational to a system that is just, that a person cannot be deprived of their life or their liberty or their property without due process of law. And the whole idea that if the people trying to throw you in prison come across evidence or maybe even proof that you're innocent, the idea as to whether the defense should be aware of that so that they can make the judge aware of that, that's one of those items that I think for a lot of people just sounds like common sense. It just sounds like fundamental fairness, fundamental justice. So I really see this as a bedrock constitutional principle, even if it were not a major historic Supreme Court case, which of course it is.
Well, extremely well said. So let's break this down a little bit further. The fact that Kato did not know about the Brady motion, does this say more about Kato or about President Biden nominating such an individual?
I think it says something about both. It certainly raises questions about the vetting process, but not knowing something, like like what is Brady v. Maryland? What is a Brady motion? That speaks to the knowledge of the nominee, and the idea that this sort of thing would not be caught during the vetting process. That says something about the Biden White House. And then, because I don't know if we're transitioning into this point or not, but I'll say to then confuse Brady, which is about due process, with the Second Amendment, which is a different fundamental right in the Constitution, suggests that he doesn't know much about that fundamental right either. And some people might be concerned that we're starting to see a pattern here.
Yeah, that's a great point. In fact, had we played more of the clip a while ago, he went on, and like you just said, he was confused. He was thinking Brady had something to do with the Second Amendment. So he doesn't even know about the most basic constitutional provisions protecting innocent people. But evidently, he doesn't know a whole lot about Second Amendment issues and constitutional law from that perspective. You brought up something interesting, Ken. I want to come back to this because I think it's interesting, and I'd like to explore this a little bit more. You said that this is a pattern. All right, so this is fitting some sort of pattern, this nomination coming from the Biden administration, who we all know has been so committed to nominating absolutely radical individuals, to people radically committed to the far left-wing agenda. That's what primarily his nominees have consisted of. So to have someone like this so seemingly unaware of constitutional law, does this fit the pattern that Biden has demonstrated in the nominations he's put forward previously?
Well, I think that's a growing concern, Congressman. First of all, with this nominee, first it's the Fifth Amendment due process clause and the 14th Amendment due process clause. Then it's the Second Amendment right to keep and bear arms. So you see a pattern with this individual. It's a question of how many other fundamental rights is he not aware of that it would be his sworn duty as a judge to faithfully uphold? But then as we look comparing him to other nominees, as you were just referencing, as I quote in the news story that I wrote earlier today, this comes on the heels of another judicial nominee who was asked what's in Article 1 of the Constitution. Now, that's something that non-lawyers don't need to know, but lawyers need to know it and judges need to know it. Article 1, as you would know well, having served in Congress, that lays out what the powers of Congress are. It lays out the categories where Congress is able to pass laws and how members of Congress are elected and what their term is and who's eligible to serve in Congress. And everything about the functioning of the legislative branch of the federal government is in Article 1. And this nominee didn't know anything about Article 1. Then she was asked about Article 2. Well, that's about the powers of the U.S. president. That's about the structure of the executive branch and the duties of the U.S. president, including his sworn duty to see to it that the laws are faithfully executed. She didn't know anything about Article 2 either. So there you start to see another pattern. And again, the Constitution, whether it's the powers of government, like in Article 1 or Article 2, or whether it's specific rights of citizens, like we see in the Second Amendment, in the 14th Amendment, in the First Amendment, free speech, religious liberty, all of those issues, all of that, all of the Constitution is the supreme law of the land. So if there is one area of law where we really want to make sure that every judge knows that area of law, it's the U.S. Constitution that we need them to know.
Absolutely. Well, Ken, thank you. You're spot on with that. I do want to shift gears, but I want to real quickly, one more question before we change. The Senate Judiciary Committee has not yet scheduled a vote on Cruz' nomination, but historically, these type of positions are pretty hard to reject, or at least uncommonly rejected. So what do you kind of expect is going to happen at the end of the day?
Well, we have seen a number of very controversial nominees from this president, not just for the federal courts, but for senior administration positions as well, that have been confirmed many times on a party line vote, sometimes with a handful of Republicans crossing over. So you're right to see a nomination to the federal district bench fail is certainly uncommon. But I think it's an issue of we're going to have to see. This will be this will perhaps show how committed Senate Democrats are to walking in lockstep and supporting the president no matter what. I think this will be an issue of seeing what discipline Chuck Schumer has as Senate Majority Leader in terms of keeping senators in line. But I think there'll also be questions regarding a number of moderate Republican senators as to whether this is something that they want to take a stand on. So it's I think so. The jury is still out on this.
Yep. Okay, well, it is going to be interesting, but if there's ever a time for the uncommon to become common, now would be a good time. If I can, let me switch gears. We've only got a couple of minutes left, but yesterday the dean of the Stanford University Law School released a 10-page letter in which she announced that there will be no consequences for those students who heckled and silenced a federal judge who was speaking on their campus the other day. Your thought on that? No disciplinary action for these students.
I think that's completely shameful. It is when you're being considered to be a lawyer, getting a law degree doesn't make you a lawyer. You have to get your law degree. Actually, some states don't even require a law degree, but generally speaking, you have to get a law degree. Then you have to pass the bar exam, and then you have to pass other eligibility requirements, including having a character and fitness, including having a character and fitness committee. That says you are fit in terms of your integrity, in terms of your temperament, in terms of your professionalism to be an attorney. The idea of an attorney heckling a judge is astounding. That's the sort of activity that if you're a licensed attorney and you were to do that to a judge in his courtroom, I mean, you could be stripped of your law license. You could be disbarred. for something like that, for that kind of conduct that's unbecoming an attorney. So it is, I think this gets to a real issue as to whether these people can be expected to act in a professional and respectful manner, including occasionally doing the duty of having to faithfully represent someone whose views they might not share. But it's still their duty to do a good job of articulating those views to the court and to the judge. And if they don't respect opposing views and don't respect the judges who are deciding those views, I don't see how the legal profession can work if it has people like that in it.
Well, and you think that many of these students are, in one day, in the not too distant future, very likely going to be arguing in court, or some of them actually wearing a robe while they're judging others. And the fact that they've heckled and silenced a sitting judge is extremely, extremely disturbing. Ken Klukowski, as always, it's an honor to have you on Washington Watch. Thank you for keeping the torch ablaze. Thank you for joining us this evening on the program.
Thank you, sir. God bless.